This lecture presents my submission to the European Commission's consultation in Case DMA.100209 concerning Google search data sharing under 611 of the Digital Markets Act. The purpose is to explain why 611 matters for contestability in search, why search data is unusually difficult to anonymize, why the Commission's preliminary measures risk creating a privacy fiction, and why a safer, evidence-led access architecture is needed. The background is simple but serious. Article 611 seeks to open access to ranking, query, click, and view data because those signals can improve search quality. But the same provision requires personal query, click, and view data to be anonymized. The lecture therefore argues for anonymization first, utility second, and a tiered access regime that preserves contestability without weakening the legal meaning of anonymization. My name is Dr. Mark Leiser, and I work at the intersection of digital technologies, law, and regulation. And I want to start by talking about the title of this lecture, because it's doing a lot of work. I am not saying that Article 611 is wrong. I'm saying that privacy shouldn't defeat contestability. I'm saying that the Commission must not make access to search data work by inventing a privacy fiction. By that, I mean a situation where search data is treated as anonymous because direct identifiers have been removed. A few thresholds or detectors have been applied, and the recipients have promised not to re-identify users, even though realistic lawful means of re-identification or inference may remain available. That would be dangerous for privacy, but also for the DMA itself, because a legally fragile access regime will not endure. Article 611 sits at the intersection of competition, data protection, AI governance, and the wider EU digital acquis. The provision is new for many people, so I will build my argument carefully. I will introduce what the DMA is trying to do, what contestability means, why search data matters, why anonymization is the central legal condition, and why I argue for a safe search data access regime rather than a single transformed record-level dataset. I want the talk to be passionate because the stakes are real, but also accurate because sloppy rhetoric in this area creates bad law. This is the map of my lecture. The first move is the DMA and contestability. I will explain why Article 611 exists and why search data can be a barrier to entry. The second move is 611 itself. I will set out the provision in ordinary language, access to ranking, query, click, and view data on FRAND terms, but with a mandatory anonymization condition from personal query, click, and view data. The third move is the privacy problem. Search logs are not ordinary telemetry. They are semantic, contextual, behavioral. They may also contain personal data about someone other than the searcher. The fourth move is the privacy fiction. This is the risk that the Commission's proposed technical and contractual architecture treats data as anonymous when the real-world risk of identification has not been sufficiently removed. The fifth move is my proposed architecture, a safe search data access regime. This is not a call to weaken the DMA. It's an attempt to make the provision workable. The phrase I want you to keep in mind is this. The aim is not to make the DMA smaller, but to make Article 611 legally durable enough to work. I want to signal that the slides I've written here are not designed also as a wall of text, the prompts for legal and a governance argument that you may not know or may be very familiar with. And the real substance of what I have to say is in the explanation I give over the bullet points on my slides. The core question is whether Article 611 can guide conduct or whether it will manufacture uncertainty. That may sound abstract, so let me make it concrete. The Commission wants to specify how Google must share search data with third-party online search engines. That is a contestability intervention. It is intended to make a market more challengeable by reducing the data advantage of a gatekeeper. But the same intervention runs into a hard legal condition. personal query, click, and view data must be anonymized. The risk is that we end up with a regime that is neither clear enough for Google, nor safe enough for users, nor useful enough for recipients. That would be a classic failure of digital governance, a strong political objective implemented through concepts that do not guide behavior. Legal certainty is not anti-rights. Legal certainty is one of the conditions of rights protection, because actors need to know what the law requires before they design systems, build APIs, sign contracts, transfer data. My submission asks the Commission to respect the legal sequence: anonymization first, then utility. It also asks the Commission to avoid creating another operational meaning of anonymization. We already have the GDPR, the Digital Omnibus Debate, DPA guidance, the AI Act, the Data Act, the DSA, and data space initiatives, all pulling on these concepts. Article 611 should not add another layer of complexity or fog. Before we get to the specific provision, we need to locate and discuss the DMA. The Digital Markets Act is an ex-ante regulation for platform power. Ex-ante simply means that the obligations apply in advance once a firm is designated as a gatekeeper, rather than only after years of case-by-case enforcement. That is important because the DMA is not just competition law with a new name. It is a regulatory instrument that starts from the view that some digital markets are structurally shaped by gatekeepers. These firms control access, data, infrastructure, interfaces, and sometimes whole ecosystems. The law therefore imposes obligations intended to preserve fairness and contestability. Fairness concerns the treatment of business users and end users. Contestability concerns whether markets remain genuinely challengeable. In the search context, contestability does not mean that a rival can technically launch a search engine. It means that a rival has a realistic opportunity to improve, attract users, and discipline the incumbent. Article 611 is one of the DMA's most direct attempts to deal with a data advantage. It says, in effect, that if search quality improves through data feedback loops, then third-party online search engines may need access to some of those signals. But the DMA does not give a blank check. It also contains an anonymization condition. That's the tension that I'll keep returning to throughout this lecture. Article 611 is a data access duty with an anonymization condition. The provision requires the gatekeeper to provide third-party undertakings providing online search engines with access on fair, reasonable, and non-discriminatory terms to ranking, query, click, and view data generated by end users. For those new to the language, FRAND means that access terms should not be unfair, unreasonable, discriminatory, or structured so that only certain favored recipients can use them. But the second part of the provision is just as important. Any query, click, and view data that constitutes personal data should be anonymized. That's not a soft recital. It's the operative text. Recital 61 tells us data quality and usefulness matter, but a recital cannot reverse the sequence created by the provision itself. My reading is therefore pretty straightforward. First, determine whether the relevant query, click, or view data is personal data. Second, if it is, anonymize it. Third, once anonymization is achieved, preserve as much useful access as possible. This does not mean utility is irrelevant. It means utility is not a reason to lower the legal threshold. If we treat usefulness as though it can dilute anonymization, Article 611 becomes an unconstrained data sharing obligation. That is not what the legislature wrote. To understand why 611 exists, one has to understand search as a feedback system. Search quality is not produced only by clever ranking formulas in the abstract. It is produced through constant interaction. If you think about it, users enter queries. The search engine returns results. The user sees some results and not others. The user clicks, reformulates, scrolls, returns, or abandons the search. The system learns from those interactions. Over time, these feedback loops help with ranking, query understanding, spelling, freshness, local relevance, and presentation. This is where contestability becomes concrete. A smaller search engine might have the legal right to exist, but it lacks those comparable feedback signals. It may struggle to improve quality at the same pace. Article 611 is therefore aimed at the gatekeeper advantage created by search data scale. But the design challenge is hard because the same data that helps search systems learn also tells stories about us, human beings. Search data can reveal our fears, our needs, our illnesses, our vulnerabilities, our beliefs, our movements and intentions. So the key implementation question is not whether search data has value. It plainly does. The question is how to preserve some of that contestability value without lowering the anonymization requirement that protects European users. The four categories in Article 611 are not interchangeable. Query data is the text and metadata around what a user searched for. It may be the most semantically revealing category because a query can directly express a need or a fear. View data concerns what the user actually saw: URLs, modules, formats, search results. This matters because clicks mean something different depending on what was shown. Click data concerns user interaction: clicks, clickbacks, scrolling, hovering, expansion, and other forms of engagement. It's useful for relevance and for satisfaction, but it's also behavioral data. Ranking data concerns positions and prominence. This is essential because a click on a result at the top of the page means something different from a click on a result buried lower down. Together, these categories form a compressed record of intention, of context, of our behavior. This is why they matter for parity, utility, and contestability. It's also why they cannot be treated as homogeneous data bundle. Some fields may be easier to anonymize and export. Some may need aggregation. Some may require stronger suppression. Some may be suitable only for controlled access after anonymization is achieved. The law should reflect those differences rather than assuming that one record-level dataset can solve everything. Search logs are a worst-case domain for casual anonymization. They are semantic because they contain language. They are contextual because meaning changes when query text is combined with time, location device, interface, and result shown. They are behavioral because clicks and query reformulations reveal patterns over time. They are also sometimes third-party exposed. A query may reveal personal data about the person who searched, but it may also contain information about a child, a colleague, a neighbor, a patient, a suspect, a victim, a public official, or another person. At scale, the system will have no reliable way to determine which is true. This is one reason why I'm careful in the submission I wrote about personal data embedded in query text. The safer assumption is that such data may form part of the end-user anonymization problem unless the contrary can be established. Otherwise, one creates an artificial gap. The searcher is protected, but personal data in the query is treated as if it belongs to someone else and can be moved outside of Article 611. This is not a safe or coherent approach. It's also why identifier removal is not enough. If a query string or combination of query, metadata, and clicks remain identifying, removing account IDs or IP addresses does not necessarily solve the problem. This slide distinguishes three concepts that are too often blurred. Personal data is information relating to an identified or an identifiable natural person. Recital 26 of the GDPR asks us to consider means reasonably likely to be used by the controller or another person to identify the natural person. That's contextual, but it's not imaginary. It's about realistic, objective means, including cost, time, available technology, and technological developments. Synonymization is different. Article 4.5 of the GDPR defines it as processing that prevents attribution without additional information, where that additional information is kept separately and protected. Synonymization is valuable. but it remains within the scope of the GDPR. Anonymization is stronger. It means that the data subject is not or no longer identifiable. Article 611 requires anonymization where query, click, and view data constitutes personal data. The distinction is not pedantic. It is the legal threshold. If the Commission treats pseudonymize or partially transformed data as anonymous because contracts, we'll come to that, prohibit re-identification, it risks creating a DMA-specific category of anonymous enough by contract. That is exactly the kind of conceptual drift that undermines legal certainty. Contextual analysis is necessary, but it must not become a convenient label for weak anonymization. This slide captures the legal sequence. First, ask whether the data is personal data. Second, ask whether it has been anonymized. Third, ask what means are reasonably likely to be used by the recipient or another person. Fourth, ask what safeguards support the analysis. Fifth, once anonymization is achieved, ask what utility remains. The order matters. If we assess privacy and utility as though they are equal variables to be traded off, we risk lowering the legal threshold. Article 611 does not say the gatekeeper must share useful data and then mitigate privacy as far as convenient. It says personal query, click, and view data shall be anonymized. That does not make utility irrelevant. Recital 61 exists. The access obligation exists. Contestability matters, but usefulness matters after anonymization has been achieved. This is why I say anonymization first, utility second. That formulation can sound blunt, but it's the only way to keep the operative text, the GDPR, and the contestability purchase in the right relationship. A useful data set that is not anonymous fails data protection. A data set that is anonymized only by destroying all meaningful access may fail the purpose of the DMA. The answer is not to lower either standard, but to design a better access architecture. Now, the Commission's proposal should be treated with respect. It's detailed and serious. It's good. It's just not simply saying remove names and publish as a spreadsheet. The preliminary measures contain eligibility rules, a data scope, daily API access, technical measures, contractual restrictions, assurance, pricing, samples, suspension, and termination. That is why my position is constructive but not deferential. What I mean here is that the fragility lies in the theory of anonymization. The proposed design appears to rely on a limited technical layer, followed by contractual promises by recipients not to re-identify, link, augment, misuse, or onward share. The Commission's apparent view is that the combination of technical measures and contractual controls can reduce residual re-identification risk to a level compatible with anonymization. Let me say that again. The Commission's apparent view is that the combination of technical measures and contractual controls can reduce residual re-identification risk to a level compatible with anonymization. My concern is that the technical layer may not do enough, and that the contractual layer is being asked to do too much. If the data set remains identifying through realistic lawful means, then the existence of a contract does not alter the legal status of the data. That's why I call it a privacy fiction risk. So the issue is not whether the Commission has taken privacy seriously. It has. The issue is whether the proposed solution is legally stable enough for a data set as sensitive as search logs. Now this slide states the problem directly. The technical layer may fail because detectors miss personal data, thresholds misclassify, and semantic combinations remain identifying. The contractual layer may fail because a promise not to re-identify does not mean the means to identify do not exist. These are different questions. It is the one thing to say a recipient is legally prohibited from doing something. It's another thing to say the recipient does not have the reasonably likely means to do it. Recital 26 asks about means reasonably likely to be used. It does not simply ask whether a recipient has promised not to use them. I'm not saying contracts are irrelevant either. They matter. They may make certain means unlawful. They may shape the recipient environment. They may create sanctions, audits, and enforcement triggers. But if the technical anonymization layer is weak, the contract cannot rescue the status of the data. This is particularly important where recipients may hold other data sets, public sources, their own search logs, advertising or analytics data, browser data, location data, panel data, or model outputs. Those resources may make linkage or inference realistic. A serious anonymization analysis has to take that into account. Now, I've given you two hypotheticals here. And what I want to do is show why ordinary lawful means matter. In the first, a user enters a distinctive run of searches. One query contains something like, my name is X, but X is a common noun and is not caught by a name detector, like April or summer. Other queries reveal a city, a university, a profession, and a narrow institutional connection. A recipient with public professional profiles, like on LinkedIn, or institutional websites, or its own search logs may be able to connect the dots. The second hypothetical concerns influence over the dataset. If the recipient understands that certain entities appear only above a certain threshold, it may lawfully run searches or ask others to run searches, thereby affecting what later appears. This does not require hacking. It does not require dark web databases. It uses lawful behavior and the recipient's own knowledge. The point is not that re-identification will always happen. The point is that the legal test does not require certainty of re-identification. It asks whether means are reasonably likely to be used. If those means exist in the concrete recipient context, one cannot simply say the data is anonymous because the recipient signed a contract. That's the legal discipline I want the Commission to preserve. Now, private enforcement is not a substitute for legal certainty. The Commission's contractual model may create uncertainty in at least three ways. First, it may complicate role allocation. If Alphabet is required to impose detailed controls on recipients, one can imagine arguments about influence over the purposes and means, and therefore about controller status. Contractual labels are not decisive under the GDPR. Second, if a recipient breaches the contract, does that automatically make the processing unlawful under the GDPR? That's not straightforward either. Third, if the privacy architecture depends on Alphabet enforcing contracts against recipients, then the public law condition of anonymization becomes partially dependent on private enforcement after the fact. That's the wrong place to locate the safeguard. Contracts are important as access conditions, assurance obligations, breach triggers, but they should not carry the legal burden of transforming a technically fragile dataset into anonymous data. This matters not only for Google, it matters for recipients, data subjects, DPAs, and the Commission. Everybody needs to know who is responsible for what and on what legal basis. A regime built on ambiguity is unlikely to survive. Now, clean rooms, I propose clean rooms as a means of kind of closing this gap. But clean rooms, and the way that I've used this phrase in my submission, require careful clarification. I do not use the term to mean a space where non-anonymous data can be placed and then treated as safe because access is restricted. That would simply recreate the privacy fiction in a different form. In my submission, a clean room or a controlled API has a narrower role. It is a controlled environment for data that has already met the relevant anonymization threshold in the recipient context. but where ordinary download would create marginally elevated operational combination or output leakage risks. In that setting, additional controls can help. No local copy, output checks, query whitelisting, logging, rate limits, role controls, extraction testing, and auditability. But if the underlying data cannot be anonymized to the 611 standard, the answer is not to put it in a clean room and call it anonymous. The answer is stronger technical treatment, aggregation, suppression, regulator review, or privacy-tested model and output access. This is an important distinction because clean room language is fashionable. It can be useful, but only if we are clear that it is not a laundering device for non-anonymous data. The thing I propose in my submission to the Commission is called a Safe Search Data Access Regime, and this is my proposed alternative to a single transformed record-level dataset. It starts with a simple idea. Access should not always mean unrestricted possession. Some information can be public methodology or synthetic preview. Some signals can be provided through privacy-preserving aggregates. Some lower-risk common tail records may be suitable for ordinary export. But some data that has been anonymized but is not suitable for download may need controlled access. Some contested suppressions may need regulator escrow or expert review, and misuse should trigger suspension or termination. This regime is not anti-access. In fact, it may preserve more useful access than a blunt export model because it avoids the all-or-nothing choice between unsafe disclosure and total suppression. It also aligns the access modality with the risk and the value of the data slice. The critical point is still that anonymization comes first. Controlled access does not substitute for anonymization. It governs the form of access after the relevant standard has been met or after the relevant output has been privacy tested. This is what I mean by legally durable access architecture. The AUIA, or Anonymization and Utility Impact Assessment, is the evidence layer. It stands for Anonymization and Utility Impact Assessment. I do not want another paper exercise. I want a structured evidential method. The AUIA should begin with anonymization. It should ask what fields exist, what is removed, what is generalized, what is binned, what is retained, and what combinations remain. It should ask whose data is at issue and in which recipient context the end user may still be identifiable. It should model threats, singling out, linkability, inference, active attacks, auxiliary data linkage, AI-assisted linkage, model-mediated inference. Only after that should it assess utility, ranking, query understanding, freshness, local search, head and torso learning, carefully controlled rare query analysis, and evaluation of the online search engine function. This ordering matters. The AUIA that I propose should not be a mechanism for trading down anonymization. It should be the mechanism that shows whether anonymization is met and then what value remains. The non-confidential version should help recipients understand the system, while the confidential version should be given to the Commission, DPAs, or trusted auditors enough to detail to test the claims. Either privacy or utility can be faked if assessed alone. The AUIA forces both to be evidenced. Now, the other thing that the Article 611 DMA provision does is it creates eligibility for third parties to have access to that data. And an AI-enabled search makes Article 611 even more important and more dangerous. The Commission's preliminary measures appear to include AI chatbots with online search engine functionality. I understand why. Search is increasingly delivered through conversational interfaces, AI assistants, retrieval augmented outputs. A categorical exclusion would be formalistic, but eligibility must be functional. The relevant question is not whether a broader AI service contains a search-like component. The question is whether the requested data is necessary for a genuine online search engine function. Access should follow retrieval, indexing, ranking, query understanding, SERP interaction, and evaluation of that function. It should not extend to the entire AI surface. Article 6.1 should not become a route for general-purpose model training, fine-tuning of non-online search engine systems, model grounding outside of the online search engine function, advertising enrichment, or identity graph improvement, profiling, or unrelated optimization. That is not anti-AI. It's simply respecting the statutory purpose. If the legal basis is contestability in online search, then the permitted use should be tied to the online search engine function. Otherwise, the Digital Markets Act will quietly become an AI data pipeline, which is not what 6.11 was designed to do. Now, one possible objection to my proposal is that safeguards like the AUIAs and tiered access will delay implementation. And I'll admit that's a serious concern. So my answer to that is phasing. The Commission can preserve its implementation timetable by sequencing obligations. In the first phase, provide public documentation, licensing templates, synthetic samples, request forms, and the non-confidential AUIA framework. In the second phase, finalize the core search dataset and launch lower risk common tail access. In the third phase, introduce privacy-preserving aggregate APIs, reason code reporting, utility dashboards, and recipient certification. In the fourth phase, pilot controlled access for narrow categories where anonymization has been achieved, but ordinary download is still inappropriate. Later phases can include independent red team testing, level 2 assurance, periodic AUIA updates, and Commission DPA pattern review. This approach avoids the false choice between immediate unsafe access and indefinite delay. It also prevents safeguards becoming a tactic of obstruction. A more careful regime need not be slower if the Commission sequences it intelligently. Phasing is a governance tool. It allows the provision to start operating while the most difficult modalities mature. Now, why does this matter beyond one consultation? Because it touches the meaning of anonymization across the entire EU digital acquis. The Union, unless you're living under a rock, is already debating the boundary between personal data, pseudonymization, and anonymization in the digital omnibus. There is a lot of bad information coming out about why this is a bad idea to create legal certainty in the definition of personal data. DPAs and the European Data Protection Board are developing guidance and joint opinions. The DSA has its own data access architecture. The Data Act and data spaces are concerned with access and reuse. The AI Act raises questions about model development, evaluation, and governance. If 6.11 creates a DMA-specific, contract-dependent meaning of anonymization, that instability will not stay confined to Google or Alphabet search. It will travel. It will affect how lawyers, regulators, engineers, and firms understand data sharing across the digital rulebook. This is why I keep using the phrase legal certainty. Legal certainty is not a slogan for deregulation. It is a condition for governable rights protection. If actors cannot understand whether data is personal, synonymous, or anonymous, then the answer shifts from one regime to another without a clear rationale. The law will stop guiding conduct. Article 6.11 is an opportunity to show that the DMA and the GDPR can be implemented coherently. It should not become another source of conceptual drift. This slide summarizes my recommendations. First, reaffirm that anonymization is the condition for sharing personal query, click, and view data. Second, allow stronger technical anonymization, even where some utility is lost. Third, recast those contracts as safeguards, access conditions, and breach triggers, not as substitutes for anonymization. Fourth, reject raw form parity as the governing standard and instead use effective access to contestability value under FRAND terms. Fifth, adopt the AUIA so that claims about privacy and utility are evidenced and reviewable. Six, ring-fence AI access to the online search engine function and prohibit service-wide AI use, general model training, fine-tuning of non-OSE systems, model grounding outside the OSE function, ad enrichment, identity graphs. These recommendations are not a privacy veto. They're a way to make the provision workable. The Commission does not have to choose between reckless disclosure and symbolic access. It can design a tiered, evidence-led regime that respects both the DMA and the GDPR. That's the line I want to hold. Meaningful access, but not the price of weaker meaning of anonymization. Let me end with the habits I want to keep and the habits I want to reject. Keep 611 as a serious contestability tool. Keep anonymization as the legal condition. Keep contextual analysis, but make it disciplined and evidence-led. Keep tiered access and independent review. Keep AI tied to the online search engine function. Reject privacy as a veto over the DMA. Reject utility as a reason to lower anonymization. Reject contracts as anonymization machinery. Reject clean rooms as a label for non-anonymous disclosure. Reject yet another meaning of anonymization. The final formulation is deliberately spare. Do not weaken 611. Do not pretend search logs become anonymous by formula. Do not lower anonymization to preserve utility. Once anonymization is achieved, preserve contestability through a tiered, evidence-led, and independently reviewable access regime. That is, in my view, the only way Article 611 can work as a serious access obligation while protecting users, giving recipients useful signals, respecting the GDPR, and preserving legal certainty across the EU digital acquis. Thank you, and I look forward to the discussion.